I am going to start a series on our constitution that is related from the Union Legislature. As has been explained at the outset, our constitution has adopted the parliamentary system of government, which effects a harmonious blending of the legislative and executive organs of the state, inasmuch as the executive power is wielded by a group of members of the legislature who command a majority in a popular chamber of the legislature and remain in power so long as they retain that majority. The functions of parliament as the legislative organ follow from the above features of the parliamentary system. Providing the cabinet, it follows from the above that the first function of the parliament is that of providing the cabinet and holding them responsible. Though the responsibility of the cabinet is to the popular chamber, the membership of the cabinet is not necessarily restricted to that chamber, and some of the members are usually taken from the upper chamber. Control of the cabinet, it is necessary corollary from the theory of the ministerial responsibility that it is a business, that it is corollary from the theory of ministerial responsibility that it is a business of the popular chamber to see that the cabinet remains in power so long as it retains the confidence of the majority of the in that house. This is expressly secured by Article 73, Article 75(3) of our Constitution. Criticism of the cabinet and of individual matters. In modern times, both the executive and legislative policies are initiated by the cabinet, and the importance of the legislative function of parliament has to that extent diminished from the historical point of view. But the critical function of parliament has increased in importance and is bound to increase if cabinet government is to remain a responsible form of government instead of being an autocratic one. In this function, both the houses participate and are capable of participating, though the power of bringing about a downfall of the ministry belongs only to the popular chamber, that is the House of the People, Article 75(3). While the cabinet is left to formulate the policy, the function of parliament is to bring about a discussion and criticism of that policy on the floor of the House, so that not only the cabinet can get the advice of the deliberative body and learn about its own errors and deficiencies, but the nation as a whole can be apprised of an alternative point of view on the evaluation of which representative democracy rests in theory. An organ of information. As an organ of information, parliament is more powerful than the press or any other private agency, for parliament secures the information authoritatively from those in the know of things. The information is collected and disseminated not only through the debates but through the specific medium of questions to ministers. Legislation. The next function of the legislature is that of making laws. Article 107, 208, 245, which belongs to the legislature equally under the presidential and parliamentary forms of government. In India, since the inauguration of the Constitution, the volume of legislation is steadily rising in order to carry out manifold development and other measures necessary to establish a welfare state. Financial control. Parliament has the sole power not only to authorize expenditure for the public services and to specify the purposes to which that money shall be appropriated, but also to provide the way and means to raise the revenue required by means of taxes and other impositions, and also to ensure that the money that was granted has been spent for the authorized purposes. As under the English system, the lower houses possesses the dominant power in this respect. Under our constitution, Article 109, the Parliament of India consists of President and two houses. The lower house is called House of People, while the upper house is known as Council of States. Article 79. In the Hindi names Lok Sabha and Rajya Sabha have been adopted by the houses of the people, House of People and the Council of States respectively. The President is a part of legislature, like English crown, for even though he does not sit in Parliament except for the purpose of delivering his opening address, a bill passed by the House of Parliament cannot become law without the President's assent. The other legislative functions of the President, such as the making of ordinances, while both houses are not in sitting, have already been explained. The Council of States shall be composed of not more than 250 members, of whom A 12 shall be nominated by the President, and B the remainder shall be representative of the states and union territories elected by the method of indirect election. Article 80. Nomination. The 12 nominated members shall be chosen by the President from amongst persons having special knowledge or practical experience in literature, science, art and social service. The Constitution thus adopts the principle of nomination for giving distinguished person a place in the upper chamber. Representation of states. The representative of each state shall be elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of the single transferable vote. Representation of union territories. The representatives of the union territories shall be chosen in such manner as Parliament may prescribe. Article 85. Under this power, Parliament has prescribed that the representatives of union territories to the Council of States shall be directly elected by members of an electoral college for that territory in accordance with the system of proportional representation by means of the single transferable vote. The Council of States thus reflects a federal character by representing the units of the federation, but it does not follow the American principle of equality of state representation in the second chamber. In India, the number of representatives of the state to the Council of States varies from 1 Nagaland to 31 Uttar Pradesh. The House of People has a variegated composition. The Constitution prescribes a maximum number as follows: not more than 530 representatives of the states, not more than 20 representatives of union territories. Article 81(1)(b). Not more than 2 members of Anglo-Indian community nominated by the President if he is of opinion that Anglo-Indian community is not adequately represented in House of the People. Article 331. The representatives of states shall be directly elected by the people of the state on the basis of adult suffrage. Every citizen who is not less than 18 years of age and is not otherwise disqualified, as for example by reason of non-residence, unsoundness of mind, crime or corrupt or illegal practice, shall be entitled to vote at such election. Article 326. There will be no reservation of seats for any minority community other than the scheduled caste and scheduled tribes. Article 330, 341, 342. The bulk of the members of the House are thus directly elected by the people. The members from the Union territories are to be chosen in such manner as Parliament may by law provide. Under this power, Parliament has enacted that representatives of all the union territories shall be chosen by direct election. 2 members may be nominated from the Anglo-Indian community by the President of the House of the People if he is of opinion that the Anglo-Indian community has not been adequately represented in the House of the People. Article 331. The election of the House of People, being direct, requires that the territory of India should be divided into suitable territorial constituencies for the purpose of holding such elections. Article 81(2), as it stands after the Constitution 7th Amendment Act 1956, has provided for uniformity of representation in two respects: as between the different states and b as between the different constituencies in the same state. Thus, there shall be allotted to each state a number of seats in the House of the People in such manner that the ratio between the number and the population of the state is so far as practicable for same for all states, and each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it is so far as practicable the same throughout the state. While the system of separate electorates was abandoned by the Constitution, the system of proportional representation was partially adopted by the second chamber in the Union and state legislatures. As regards the Council of States, proportional representation by the single transferable vote has been adopted for the indirect election by the elected members of the Legislative Assembly of each state in order to give some representation to minority communities and parties. Article 84. Similarly, proportional representation is prescribed for election to the Legislative Council of a state by electorates consisting of municipalities, district boards, and other local authorities, and of graduates and teachers of 3 years standing resident in the state. Article 171(4). As regards the House of the People, Article 81, and the Legislative Assembly of a state, however, a system of proportional representation has been abandoned, and instead the Constitution has adopted the single member constituency with reservation of seats at the general election for some backward communities, namely the scheduled caste and scheduled tribes. Article 330, 332. The reasons for not adopting proportional representation for the House of the People was thus explained in the Constituent Assembly. Proportional representation presupposes literacy on a large scale. It presupposes that every voter should be illiterate, at least to the extent of being in a position to know the numerals and mark them on the ballot paper. Having regard to the position of literacy in this country at present, such presumption would be extravagant. Proportional representation is ill-suited to the parliamentary system of government laid down by the Constitution. One of the disadvantages of the system of proportional representation is the fragmentation of the legislature into a number of small groups. Although the British Parliament appointed a royal commission in 1910 to consider the advisability of introducing proportional representation, and the commission recommended it, Parliament did not eventually accept the recommendations of the commission on the ground that the proportional representation would not permit a stable government. Parliament would be so divided into small groups that every time anything happened which displeased certain groups in Parliament, they would on those occasions withdraw support to the government, with the result of that government losing the support of certain groups would fall to pieces. What India needed, at least in view of existing circumstances, it was a stable government, and therefore proportional representation in the lower house to which the government would be responsible could not be accepted. In this connection, Dr. Ambedkar said in the Constituent Assembly, I have not the least doubt in my mind whether the future government provides relief to the people or not. Our future government must do one thing: they must maintain a stable government and maintain law and order. The Council of States is not subject to dissolution. It is permanent body, but as nearly as possible, 1/3 of its members retire on expiration of every second year in accordance with provision made by the Parliament in this behalf. It follows that there will be an election of 1/3 of the membership of the Council of States at the beginning of every third year. Article 83(1). The order of retirement of the members is governed by the Council of States term of office of members. Order 1952 made by the President in exercise of powers conferred upon him by the Representation of People Act 1951. The normal life of the House of the People is 5 years, but it may be dissolved earlier by the President. On the other hand, the normal term may be extended by an act passed by Parliament itself during the period when the proclamation of emergency made by the President under Article 352 remains in operation. The Constitution, however, sets a limit to the power of Parliament, thus to extend its own life during a period of emergency. The extension cannot be made for the period exceeding 1 year at a time, that is by the same act of Parliament, and in any case such extension cannot continue beyond a period of 6 months after the proclamation of emergency ceases to operate. Proviso to Article 83. The President's power to summon either House, to prorogue either House, and C to dissolve the House of the People by already been noted in chapter the Union Executive Ante. As regards summoning, the Constitution imposes a duty upon the President, namely that he must summon each House at such intervals that his 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. Article 85(1). The net result of this provision is that Parliament must meet at least twice a year, and not more than 6 months shall elapse between the date on which a House is prorogued and the commencement of its next session. It would, in this context, be useful to distinguish prorogation and dissolution from adjournment. A session is the period of time between the first meeting of a Parliament and its prorogation or dissolution. The period between the prorogation of a Parliament and its reassembly in a new session is termed recess. Within a session, there are a number of daily sittings separated by adjournments which postpone the further consideration of business for a specified time, hours, days, or weeks. The sitting of a House may be terminated by dissolution, prorogation, and adjournment. As stated already, only the House of the People is subject to dissolution. Dissolution may take place in either two ways: by elux of time, that is on the expiry of its term of 5 years; by efflux of time, that is on the expiry of term of 5 years or the terms as extended during a proclamation of emergency; by an exercise of President's power under Article 85(2), while the powers of dissolution and prorogation are exercised by the President on the advice of his Council of Ministers. The power to adjourn the daily sitting of the House of the People and the Council of States belongs to Speaker and the Chairman respectively. The dissolution brings the House of the People to an end, so that there must be a fresh election, while prorogation merely terminates a session. Adjournment does not put an end to the existence of a session of Parliament, but merely postpones the further transaction of business for the specified time, hours, days, or weeks. A dissolution ends the very life of the existing House of the People, so that all matters pending before the House lapse with the dissolution. If these matters have to be pursued, they must be reintroduced in the next house after fresh election. Such pending business includes not only notices, motions, etc., but bills, including bills which originated in the council and were sent to the house, as well as bills originating in the house and transmitted to the councils which were pending in the councils on the date of a dissolution, but a bill pending in the council which has not yet been passed by the house shall not lapse on dissolution. A dissolution would not, however, affect a joint sitting of the two houses summoned by the President to resolve a disagreement between the House if the President has notified his intention to hold a joint sitting before the dissolution. Article 108(5). Though in England, prorogation also wipes all businesses pending at the date of prorogation, in India all bills pending in Parliament are expressly saved by Article 107(3). In the result, the only effect of the prorogation is that pending notices, motions and resolution lapse, but bill remains unaffected. Adjournment has no such effect on pending businesses. In order to be chosen a member of Parliament, a person must be citizen of India, must not be less than 30 years of age in the case of Council of States, and not less than 25 years of age in the case of House of the People. Additional qualifications may be prescribed by Parliament. By law, Article 84, a person shall be disqualified for being chosen as and for being a member of either House of Parliament if he holds any office of profit under the government of India or the government of any state other than an office exempted by Parliament by law, but not a minister for the Union or for a state, or if he is of unsound mind and states so declared by competent court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired citizenship of a foreign state, or is under the acknowledgement of allegiance or adherence to a foreign power, if he is so qualified by or under any law made by the Parliament. Article 102, it may be noted that sex is no disqualification for membership of Parliament, and that is the 13th general election, as may as 32 women secured election to the House of the People. If any question arises as to whether a member of either houses of Parliament has become subject to any of the above disqualifications, the President's decision in accordance with the opinion of the Election Commission shall be final. Article 103. A penalty of ₹500 per day may be imposed upon a person who sits or votes in either House of Parliament knowing that he is not qualified or that he is disqualified for membership thereof. Article 104. A member of Parliament shall vacate his seat in the following cases. Article 101. Dual membership. If a person be chosen to membership of both the Houses of Parliament, he must vacate his seat in one of the two houses, as may be prescribed by Parliament by law. Similarly, if a person is elected to the Union Parliament and the State Legislature, then he must resign his seat in the State Legislature, otherwise his seat in Parliament shall fall vacant at the expiration of the period specified in the rules made by the President. Disqualification. If a person incurs any of the disqualification mentioned in Article 102, as for example, becoming of unsound mind, his seat will thereupon become vacant immediately. Resignation. A member may resign his seat by writing address to the chairman of the Council of States or the Speaker of House of the People, as the case may be, and thereupon his seat shall be vacant. Absence without permission. The House may declare a seat vacant if the member in question absents himself from all meetings of the House for a period of 60 days without permission of the House. Under the Salaries, Allowance and Pensions of Members of Parliament Act 1954 as amended by Act 16 of 1999, a member of Parliament is entitled to a salary at the rate of rupees 2,500 per mensem during the whole term of his house, plus the allowance at the rate of rupees 150 for each day during any period of residence on duty at place where Parliament or any committee thereof is sitting, or where any other business connected with his duties as members of Parliament is transacted. Together with this, he is entitled to travelling allowances, free transit by railways, steamer and other facilities as prescribed by rules framed under the Act. He shall also be entitled to a pension since a 1976 amendment on a graduated scale for each 5-year term as member of either House. Each House of Parliament has its own presiding officers and secretarial staffs. There shall be a speaker to preside over the House of the People. In general, his position is similar to that speaker of the English House of Commons. The House of the People will, as soon as may be after its first sitting, choose 2 members of the House to be respectively Speaker and Deputy Speaker. Article 93, the Speaker on the Deputy Speaker will normally hold office during the life of the House, but his office may terminate earlier in any of the following ways: by his ceasing to be a member of the House, by resignation in writing addressed to the Deputy Speaker, and vice versa, by removal from office by a resolution passed by the majority of all then members of the House. Article 94. Such a resolution shall not be moved unless at least 14 days notice has been given of the intention to move the resolution. While a resolution for his removal is under consideration, the Speaker shall not preside, but he shall have the right to speak in and to take part in the proceeding of the House, and shall have a right of vote except in the case of equality of votes. Article 96. At other meetings of the House of the Speaker shall preside. The Speaker will not vote in the first instance, but shall have the exercise a casting vote in the case of equality of votes. The absence of vote in the first instance will make the position of the Speaker as impartial as in England, and the casting vote is given to him only to resolve a deadlock. The Speaker will have the final power to maintain order within the House of the People and to interpret its rules of procedure. In the absence of a quorum, it will be the duty of the Speaker to adjourn the House or to suspend the meeting until there is a quorum. The Speaker's conduct is regulating the procedure or maintaining order in the House will not be subject to the jurisdiction of any court. Article 122. Besides presiding over his own House, the Speaker possesses certain powers not belonging to the Chairman of the Council of States. The Speaker shall preside over a joint sitting of 2 Houses of Parliament. When the money bill is transmitted from lower house to the upper house, the Speaker shall endorse on the bill his certificate that it is a money bill. Article 110(4). The decision of the Speaker as to whether a bill is money bill is final and once the certificate is endorsed by the Speaker on a bill, the subsequent proceeding in the passage of the bill must be governed by the provisions relating to the money bills. While the office of the Speaker is vacant or the Speaker is absent from a sitting of the House, the Deputy Speaker presides except when a resolution for his own removal is under consideration. while the House of the People has a speaker elected by its members from among themselves. The chairman of Council of States, who presides over that house, performs that function ex officio. It is Vice President of India who shall ex officio be the chairman of the Council of States and shall preside over that house and shall function as the presiding officer of that house so long as he does not officiate as the President of India during a casual vacancy in that office. When the chairman acts as the President of India, the office of the chairman of the Council of State falls vacant, and the duties of the office of the chairman shall be performed by the deputy chairman. The chairman may be removed from his office only if he is removed from the office of the vice president. The procedure for which has already been stated under the Salaries and Allowance of Officers of Parliament Act 1953 as amended. The salary of chairman is the same as that of the speaker. A sumptuary allowance of such and such per mensem, but when the vice president acts as the president, he shall be entitled to the emoluments and allowances of the president, Article 65(3), and during that period he shall cease to earn the salary of chairman of the Council of State. The functions of the chairman in the Council of States are similar to those of the speaker in the House of the People, except that the speaker has certain special powers according to the Constitution, for instance of certifying a money bill or presiding over a joint sitting of the two houses, which have been already mentioned. Privileges are certain rights belonging to each house of parliament collectively, and some others belonging to the members individually, without which it would be impossible for either houses to maintain its independence of action or the dignity of its position. Both the houses of parliament as well as of a state legislature have similar privileges under our constitution. Clause 1(2) of Article 105 and 194 of our constitution deal only with two matters, viz. Freedom of speech and right of publication. Privileges relating to other matters, the position as it stands after the 44th Amendment 1978 is as follows. The privileges of members of our Parliament were to be the same as those of members of the House of Commons as they existed at the commencement of the Constitution, until our Parliament itself takes up legislation relating to privilege in whole or in part. In other words, if Parliament enacts any provision relating to any particular privilege at any time, the English precedents will to that extent be superseded in its application to our Parliament. No such legislation having been made by our Parliament, the privileges were the same as in the House of Commons, subject to such exceptions as necessarily follow from the difference in the constitutional setup in India. A reference to House of Commons was omitted in 1978. In an earlier case, the Supreme Court held that if there was any conflict between the existing privileges of Parliament and the functional rights of the citizen, the former shall prevail for the provision in Articles 105(3) and 194(3) of the Constitution, which confer upon the House of our legislatures the same British privileges as those of the House of Commons, are independent provisions and are not to be construed as subject to Part 3 of the Constitution, guaranteeing the fundamental rights. For instance, if the House of the Legislature expunges a portion of its debate from its proceeding, the other or otherwise prohibits its publication, anybody who publishes such prohibited debate will be guilty of contempt of Parliament and punishable by the House and the fundamental right of freedom of expression. Article 19(1)(a) will be no defense. But in a later case, the Supreme Court has held that though the existing privileges would not be fettered by Article 19(1)(a), they must be read subject to Article 20 to 22 and 32. The privileges of each house may be divided into two groups. A. Those which are enjoyed by the members individually, and those which belong to each House of Parliament as a collective body. The privileges enjoyed by the members individually are freedom from arrest, exemption from attendance as jurors and witnesses, freedom of speech, freedom from arrest, section 135A of the CP Code as amended by Act 104 of 1976 exempts a member from arrest during the continuance of a meeting of the chamber or committee thereof of which he is a member, or of a joint sitting of the chambers or committees, and during a period of 40 days before and after such meeting or sitting. This immunity is, however, confined to arrest in civil cases and does not extend to arrest in criminal cases or under the law of preventive detention. Freedom of attendance as witness. According to the English practice, a member cannot be summoned without the leave of the House to give evidence as a witness while Parliament is in session. Freedom of speech. As in England, there will be freedom of speech within the walls of each house in the sense of immunity of action for anything said therein, while an ordinary citizen's right of speech is subject to the restrictions specified in Article 19(2), such as the law relating to defamation. A member of Parliament cannot be made liable in any court of law in respect of anything said in Parliament or any committee thereof. But this does not mean unrestricted license to speak anything that a member may like, regardless of the dignity of the House. The freedom of speech is therefore subject to the rules framed by the House under its power to regulate its internal procedure. The Constitution itself imposes another limitation upon the freedom of speech in Parliament, namely that no discussion shall take place in Parliament with respect to the conduct of any judge of the Supreme Court or of a High Court in the discharge of his duties, except upon a motion for presenting an address to the President praying for the removal of the judge. Article 121. The privileges of House collectively are the right to publish debates and proceedings, and the right to restrain publication by others, the right to exclude others, the right to regulate the internal affairs of the House and to decide matters arising within its wall, the right to publish parliamentary misbehavior, the right to punish members and outsiders for breach of its privileges. Thus, each House of Parliament shall have the power to exclude strangers from the galleries at any time. Under the rules of procedure, the Speaker and Chairman have the right to order the withdrawal of strangers from any part of the House. To regulate its internal affairs, each House of Parliament has the right to control and regulate its proceedings and also to decide any matter arising within its walls without interference from the courts. What is said or done with the walls of Parliament cannot be inquired into in a court of law. To punish members and outsiders for breach of its privileges, each House can punish for contempt or breach of its privileges, and the punishment may take the form of admonition, reprimand, or imprisonment. Thus, in the famous Blitz case, the editor of the newspaper was called to the bar of the House of the People and reprimanded for having published an article derogatory to the dignity of a member in his capacity as a member of the House. In 1990, the Sri K.K. Tiwari, a former minister, was reprimanded by the Rajya Sabha what constitutes breach of privileges or contempt of Parliament has been fairly settled by a member of Presidents in England and India. Broadly speaking, any act or omission which obstructs or impedes either House of Parliament in the performance of its function, or which obstructs or impedes any member or any officer of such House in the discharge of his duty, or which has a tendency directly or indirectly to produce such results as may be treated as a contempt, even though there is no precedent of the offence. The different stages in the legislative procedure in Parliament relating to bills other than money bills are as follows. Introduction. A bill other than the money bill or finance bill may be introduced in either House of Parliament, Article 107(1), and requires passage in both houses before it can be presented for the President's assent. A bill may be introduced either by the minister or by a private member. The difference in the two cases is that any member other than a minister desiring to introduce a bill has to give notice to his intention and to ask for leave of the House to introduce, which is, however, rarely opposed. If a bill has been published in the official gazette before its introduction, no motion for leave or to introduce the bill is necessary. Unless published earlier, the bill is published in the official gazette as soon as may be after it has been introduced. Motions after introduction. After a bill has been introduced or on some subsequent occasions, a member in charge of the bill may make one of the following motions in regard to the bill, which that it be taken into consideration, that it be referred to the select committee, that it be referred to a joint committee of the House with the concurrence of the other House, that it be circulated for the purpose of eliciting public opinion thereon. On the day on which any of the aforesaid motions is made, or on any subsequent date to which the discussion is postponed, the principle of the bill and its general provision may be discussed. Amendments to the bill and the clause by the clause consideration of the provision of the bill take place when the motion that the bill be taken into consideration is carried. Report by select committee. It has already been stated that after introduction of the bill, the member in charge or any other member by way of an amendment may move that the bill be referred to the select committee. When such a motion is carried, a select committee of the House considers the provision of the bill but not the principle underlying the bill, which had in fact been accepted by the House when the bill was referred to the select committee. After the select committee has considered the bill, it submits its report to the House, and after the report is received, a motion that the bill as returned by the select committee be taken into consideration lies. When such a motion is carried, the clauses of the bill are open to consideration and amendments are admissible. Passing of the bill in the House where it was introduced, when a motion that the bill be taken into consideration has been carried and no amendment of the bill has been made, or after the amendments are over, the member in charge may move that the bill be passed. This stage may be compared to the third reading of a bill in the House of Commons. After the motion that the bill may be passed is carried, the bill is taken as passed so far as that House is concerned. Passage in other House. When the bill is passed in one House, it is transmitted to the other House. When the bill is received in another House, it undergoes all the stages as in the originating House. Subsequent to its introduction, the House which receives the bill from another House can therefore take either of the following courses. It may reject the bill altogether. In such a case, the provision of Article 108(1)(a) as to joint sitting may be applied by the President. It may pass the bill with amendments. In this case, the bill will be returned to the originating House. If the House which originated the bill accepts the bill as amended by the other House, it will be presented to the President for his assent. Article 111. If, however, the originating House does not agree to the amendments made by the other House and there is final disagreement as to the amendments between the two houses, the President may summon a joint sitting to resolve the deadlock. Article 108 1b. It may also take no action on the bill, keep it lying on its table. In such a case, if more than 6 months elapse from the date of the reception of the bill, the President may summon a joint sitting. Article 108 1c. President's assent. When a bill has been passed by the both houses of Parliament, either singly or at a joint sitting as provided in Article 108, the bill is presented to the President for his assent. If the President withholds his assent, there is an end to the bill. If the President gives his assent, the bill becomes an act from the date of his assent. Instead of either refusing assent or giving assent, the President may return the bill for reconsideration of the Houses with a message requesting them to reconsider it. If, however, the House has passed the bill again with or without amendments and the bill is presented to the President for his assent, after such reconsideration, the President shall have no power to withhold his assent from the bill. A bill is deemed to be a money bill if it contains only provisions dealing with all or any of the following matters: the imposition, abolition, remission, alteration, or regulation of any tax, the regulation of the borrowing of money by the government, the custody of the consolidated fund or the contingency fund of India, the payment of monies into or the withdrawal of monies from any such fund, the appropriation of monies out of the consolidated fund of India, the declaring of any expenditure to be expenditure charged on the consolidated fund of India, or the increasing of the amount of any such expenditure, the receipt of money on account of the consolidated fund of India or the public account of India, or the custody or issue of such money, or the audit of the accounts of the Union or of a state, any matter incidental to any matters specified in subclause A to F, Article 110. But a bill shall not be deemed to be a money bill by reason only that it provides for imposition of fines or other pecuniary penalties, or for the demand or payment of fees or licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. If any question arises whether a bill is a money bill or not, the decision of the Speaker of the House of the People thereon shall be final. This means that the nature of a bill which is certified by the Speaker as a money bill shall not be open to question either in a court of law or in the either house or even by the President. When a bill is transmitted to the Council of States or is presented for the assent of the President, it shall bear the endorsement of the Speaker that it is a money bill. As pointed out earlier, this is one of the special powers of the Speaker. The following is the procedure for passing of money bills in Parliament. A money bill shall not be introduced in the Council of States. After a money bill has been passed by the House of the People, it shall be transmitted with the Speaker's certificate that it is a money bill to the Council of States for its recommendation For its recommendations, the Council of States cannot reject a money bill nor amend it by virtue of its own power. It must, within a period of 14 days from the date of receipt of the bill, return the bill to the House of the People, which may thereupon either accept or reject all or any of the recommendations of the Council of States. If the House of the People accepts any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by the Houses with the amendments recommended by the Council of States and accepted by the House of the People. If the House of the People does not accept any of the recommendations of the Council of States, the money bill shall be deemed to have been passed by both Houses in the form in which it is passed by the House of the People without any of the amendments recommended by the Council of States. If a money bill passed by the House of the People and transmitted to the Council of States for its recommendations is not returned to the House of the People within the said period of 14 days, it shall be deemed to have been passed by both Houses at the expiration of the said period in the form in which it was passed by the House of People. Article 109. Generally speaking, a finance bill may be said to be any bill which relates to revenue or expenditure, but it is in a technical sense that the expression is used in the Constitution. A definition of a money bill is given in Article 110, and no bill is a money bill unless it satisfies the requirements of this article. It lays down that a bill is a money bill if it contains only provisions dealing with all or any of the 6 matters specified in the article or matters incidental thereto. These 6 specified matters have already been stated. See under money bills NT. On the question whether any bill comes under any of the subclause of Article 110, the decision of the Speaker of the House of the People is final, and his certificate that a particular bill is a money bill is not liable to be questioned. Shortly speaking, thus only those finance bills are money bills which bear the certificate of the Speaker as such. If financial bills which do not receive the Speaker's certificate are of 2 classes. These are dealt with in Article 117 of the Constitution. To the first class belongs to bill which contains any of the matters specified in Article 110 but does not consist solely of those matters. For example, a bill which contains a taxation clause but does not deal solely with taxation. Article 117(1). Any ordinary bill which contains provisions involving expenditure from the consolidated fund of the financial bill of the second class. Article 117(3). The incidents of these 3 classes of bills are as follows. A money bill cannot be introduced in the Council of States, nor can it be introduced except on the recommendation of the President. Again, the Council of States has no power to amend or reject such a bill. It can only recommend amendments to the House of the People. A financial bill of the first class, that is to say, a bill which contains any of the matters specified in Article 10 but does not exclusively deal with such matters, has 2 features in common with a money bill, as for example that it cannot be introduced in the Council of States and also cannot be introduced except on the recommendation of the President. But not being a money bill, the Council of States has the same power to reject or amend such a financial bill as it has in the case of non-financial bills, subject to the limitation that an amendment other than for reduction or abolition of tax cannot be moved in either house without the President's recommendation. Such a bill has to be passed in the Council of States through 3 readings like ordinary bills, and in case of a final disagreement between the 2 houses over such a bill, the provision for joint sitting sitting in Article 108 is attracted. Only money bills are expected out of the provisions relating to joint sitting. And Article 108(1), a bill which merely involves expenditure and does not include any of the matters specified in Article 110, is an ordinary bill and may be initiated in either house, and the Council of States has full power to reject or amend it. But it has only one special incident in view of the financial provision, that is provision involving expenditure contained in it, as for example that it must not be passed in the either house unless the President has recommended the consideration of the bill. In other words, President's recommendation is not a condition precedent to its introduction, as in the case of money bills and other financial bills of the first class. But in this case, it will be sufficient if the President's recommendation is received before the bill is considered. Without such recommendations, however, the consideration of such bill cannot take place. Article 117(3). But for this special incident, a bill which merely involves expenditure is governed by the same procedure as an ordinary bill, including the provision of a joint sitting in case of disagreement between the two houses. It has already been made clear that any bill other than a money bill can become a law only if it is agreed to by both the houses, with or without amendments. A machinery should then exist for resolving a deadlock between the two houses if they fail to agree either as to the provision of the bill as introduced or as to the amendments that may have been proposed by either house. As regards money bill, the question does not arise, since the House of the People has the final power of passing it, the other house having the power only to make recommendation for the acceptance of the House of the People in case of disagreement over a money bill. Thus the lower house the plenary power to override the wishes of the upper house, that is the Council of States. As regards all other bills, including financial bills, the machinery provided by the Constitution for resolving a disagreement between the two houses of Parliament is a joint sitting of the two houses. Article 108. The President may notify to the houses his intention to summon them for a joint sitting in case of disagreement arising between the two houses in any of the following ways. The bill is rejected by the other house, or the houses have finally disagreed as to the amendments to be made in the bill, or more than 6 months have elapsed from the date of the reception of the bill by the other house without the bill being passed by it. No such notification can be made by the President if the bill has already lapsed by the dissolution of the House of the People, but once the President has notified his intention to hold a joint sitting, the subsequent dissolution of the House of the People cannot stand in any way of the joint sitting being held. As stated earlier, the Speaker will preside at the joint sitting. In the absence of the Speaker, such person as is determined by the rules of procedure made by the President in consultation with the Chairman of Council of States and the Speaker of the House of the People shall preside. Article 108(4). The rules so made provide that during the absence of the Speaker from any joint sitting, the Deputy Speaker of the House, or if he is also absent, the Deputy Chairman of the Council, or if he is also absent, such other person as may be determined by the members present at the sitting shall preside. There are restrictions on amendments to the bill which may be proposed at the joint sitting. If after its passage in one house the bill has been rejected or has not been returned by the other house, only such amendments may be proposed at the joint sitting as are made necessary by the delay in the passage of the bill. If the deadlock has been caused because the other house has proposed amendments to which the originating house cannot agree, then first amendments necessary owing to the delay in the passage of the bill, as well as second, other amendments are relevant to the matters with respect to which the House have disagreed may be proposed at the joint sitting. If at the joint sitting of the two houses the bill with such amendments, if any, as are regard to the joint sitting, is passed by the majority of the total number of members of both the houses present and voting, it shall be deemed for the purpose of this constitution to have been passed by both the houses. It is to be carefully noted that the procedure for joint sitting as prescribed by Article 108 is confined to bills for ordinary legislation and does not extend to a bill for amendment of the Constitution, which is governed by Article 368(2) and must therefore be passed by each house separately by a special majority laid down. This is why the 43rd Amendment Bill introduced in the Lok Sabha in April 1977 could not overcome the apprehended resistance in the Rajya Sabha by resorting to a joint sitting as carelessly suggested in some newspaper articles. The 44th Amendment Bill suffered mutilation in Rajya Sabha for the same reason. At the beginning of every financial year, the President shall, in respect of the financial year, cause to be laid before both the Houses of Parliament a statement of the estimated receipts and expenditure of the Government of India for that year. This is known as the annual financial statement, that is the budget. Article 112. It also states the ways and means of meeting the estimated expenditure. In conformity with the usual parliamentary practice in the United Kingdom, the budget not only gives the estimates for ensuing year but offers an opportunity to the government to review and explain its financial and economic policy and program to the legislature to discuss and criticize it. The annual financial statement in our parliament thus contains, apart from the estimates of expenditure, the wage and means to raise the revenue. Any financial analysis of the actual receipts and expenditures of the closing year and the causes of any surplus or deficit in relation to such year, an explanation of the economic policy and spending program of the government in the coming year and the prospects of revenue. The estimates of expenditure embodied in the annual financial statement shall show separately the sums required to meet expenditure described by this constitution as expenditure charged upon the consolidated funds of India and the sums required to meet other expenditure proposed to be made from the consolidated fund of India. So much of the estimates as relates to expenditure charged upon the consolidated fund of India shall not be submitted to the vote of Parliament, but each house is competent to discuss any of these estimates. So much of the estimates as relates to other expenditure shall be submitted in the form of demands for grants to the House of the People, and that House shall have power to assent or to refuse to assent to any demand or to assent to any demand subject to a reduction of the amount specified therein. No demand for the grant shall have be made except on the recommendation of the President. Article 113. In practice, the presentation of the annual financial statement is followed by general discussion in both the Houses of Parliament. The estimates of expenditure other than those which are charged are then placed before the House of the People in the form of demands for grants. No money can be withdrawn from the consolidated fund except under an appropriation act passed as follows. As soon as may be after the demands for grants have been voted by the House of People, there shall be introduced a bill to provide provide for the appropriation out of the Consolidated Fund of India of all monies required to meet the grants so made by the House of the People, and B, the expenditure charged on the Consolidated Funds of India. This bill will then be passed as a money bill subject to the condition to that amendment shall be proposed to any such bill in either House of Parliament which will have the effect of varying the amount or altering the destination of any grant so made, or of varying the amount of any expenditure charged on the Consolidated Fund. Article 114. The following expenditure shall be expenditure charged on the Consolidated Fund of India. Article 112(3). The emoluments and allowances of the President and other expenditure relating to his office, the salaries and allowances of the Chairman and the Deputy Chairman of the Council of States and the Speaker and Deputy Speaker of the House of the People, debts, charges for which the Government of India is liable. D1. The salaries, allowances and pensions payable to or in respect of judges of the Supreme Court, the pensions payable to or in respect of judges of the Federal Court, the pensions payable to or in respect of judges of any High Court, the salary, allowances and pension payable to or in respect of the Comptroller and Auditor General of India, any sums required to signify any judgment, decree or award of any court or arbitral tribunal, any other expenditure declared by this Constitution or by Parliament by law to be charged. As has been already explained, financial business in Parliament starts with the presenting of the annual financial statement. This statement is caused to be laid by the President before both houses of Parliament. Article 112. After the annual financial statement is presented, there is a general discussion of the statement as a whole in either house. This discussion is to be general discussion relating to a policy involving a review and criticism of the administration and evaluation of the grievances of the people. No motion is moved at this stage, nor is the budget submitted to vote. The Council of States shall have no further business with the annual financial statement beyond the above general discussion. The voting of the grants, that is, of the demands for expenditure made by the government, is an exclusive business of the House of People. In the House of the People, after the general discussion is over, estimates are submitted in the form of demands for grants on the particular heads, and it is followed by a vote of the House on each of the heads. Article 113(2). After the grant are voted by the House of the People, the grants so made by the House of the People, as well as the expenditure charged on the Consolidated Fund of India, are incorporated in an appropriation bill. It provides the legal authority for the withdrawal of these sums from the Consolidated Fund of India. Similarly, the taxing proposals of the budget are embodied in another bill known as the Annual Finance Bill. This is all about today's series of the Union Legislature in the series of our Constitution. Thanks, regards.